I'm Ben Meiselas from the MeidasTouch network. I want to explain to you how Donald Trump inadvertently screwed himself by filing a petition for writ of mandamus with the Georgia Supreme Court, in addition to filing a petition for writ of mandamus with a superior court in Georgia at the same time. How Donald Trump flooding the courts with frivolous filings has backfired in Georgia, where unexpectedly, I think, for Donald Trump and Trump's legal team, the Georgia Supreme Court created precedent to undercut what Donald Trump may be trying to do in the Georgia Superior Court. And let me show you how Donald Trump walked right into it. So we've covered here on the MeidasTouch network how Donald Trump filed what I described from the outset as a completely frivolous petition with the Georgia Supreme Court for what's called a writ of mandamus. Donald Trump filed an original petition with the Georgia Supreme Court, meaning he didn't go through the other steps that you usually have to go through before going to the Supreme Court of a state, meaning you file in the trial court, then there's an appellate division, and then the Supreme Court can decide whether or not it's even going to hear a case at all. So Donald Trump didn't do that. He filed this original petition directly with the Supreme Court. And just so you know, this all relates to Fulton County, Fani Willis, the Fulton County District Attorney, Fani Willis's ongoing criminal investigation into Donald Trump's 2020 election interference. Fani Willis first presented information to what's called a special purpose grand jury, which does not have the power to indict. That just has the power to prepare a report and recommendations. That report and recommendations, by and large, is under seal. And then in this two-step process, Fulton County District Attorney Fani Willis can then present that special purpose grand jury report to an actual grand jury that has the power to indict. She doesn't have to show the special purpose grand jury report to the grand jury. She can just present new evidence to the grand jury and just basically redo the process again. But I predicted that Fani Willis was just going to do a hybrid. She'll show him the special purpose grand jury report, and she'll also put on some new witnesses before the grand jury. That grand jury has just been impaneled. It's 26 people. 3 of them are alternates. You need 16 to have a quorum. You need 12 to vote in favor of an indictment, ultimately for an indictment to take place. While we don't know what's stated in the report and recommendations, we believe Trump was recommended for a criminal indictment. All of the news is that Fani Willis is currently preparing a sprawling indictment regarding RICO and racketeering criminal charges against Donald Trump. And that's going before the grand jury now, which should vote to indict in the next 2 or 3 weeks. It may be sooner, but that's the status of the grand jury. So Donald Trump filed this original petition with the Supreme Court of Georgia directly, saying disqualify Fani Willis, disqualify the judge, Robert McBurney, who presided over the special purpose grand jury, and also quash or basically destroy the report prepared by the special purpose grand jury and any of the information that was presented to them. Make an order that the grand jury cannot hear any of this stuff and exclude that from ever being used in a criminal proceeding. Okay, so Donald Trump filed that with the Georgia Supreme Court. As I said, it's frivolous. One of the grounds for it being the frivolity here, why it's so frivolous, is because you can't just go to the Supreme Court. So I said it's going to be rejected on that basis alone. The Georgia Supreme Court agreed. They said on procedural grounds, you can't file this here first. You got to go through the process. But the Georgia Supreme Court did something very unique. And this is where I said, this is why I'm saying I believe that Donald Trump screwed himself by filing with the Georgia Supreme Court. You see, Donald Trump didn't only file with the Georgia Supreme Court on, I think it was July 13th or July 14th, and get that denied. Donald Trump also filed his petition, similar petition, where he should have filed it in the first place. Granted, I still think it's frivolous, but he filed it in the Superior Court of Fulton County. Now, there is a judicial ethics opinion that when you bring a motion, it's basically a new action that Donald Trump had to initiate against Fani Willis, the Fulton County District Attorney, and the judge, Robert McBurney, asking for their recusal, where you're asking for the recusal of a judge in a specific judicial district by judicial opinion precedent in Georgia. That now has to be transferred to another judicial district. So Fulton County is within the 5th administrative district in Georgia. That chief judge, the 5th district, who oversees Fulton County Superior Court and a bunch of other county superior courts, just transfer that to the 7th judicial district in Georgia, which actually has a lot. It's in northwest Georgia, and other than Cobb and Douglas County, has a lot of counties that voted for Donald Trump, and so that may be a more favorable jurisdiction for Donald Trump, maybe, than Fulton County in the ordinary course. So now that court has to hear Donald Trump's motion, his petition. Again, it's similar to what was filed in the Supreme Court, but this petition to recuse Fulton County District Attorney Fani Willis and recuse the judge and quash all of the evidence. Basically, Trump filed a mirror document in the Superior Court as he did with the Supreme Court. But I think what Donald Trump didn't plan on is the Supreme Court actually making a substantive ruling on his motion. You see, not only did the Supreme Court reject Donald Trump's original petition on procedural grounds, hey, you shouldn't have filed with us in the first place, go file with the Superior Court, the Supreme Court of Georgia actually made a ruling on the merits as well. And with this ruling on the merits, now Fulton County District Attorney Fani Willis can take that to whatever judge is now assigned this case and say, look what the Supreme Court just ruled. And here's what the Supreme Court ruled on the merits. Moreover, even if the petition were procedurally appropriate, petitioner, meaning Trump, has not shown that he would be entitled to the relief he seeks. As an initial matter, neither In re Floyd County Grand Jury nor Harris v. Edmonds, which are cited by Donald Trump, just cases cited by Trump, which are cited by Trump in support of a quashal as an appropriate remedy here, they don't apply to these facts. Those cases address situations in which a regular grand jury included in its presentments to the Superior Court and therefore published in a public way a report charging or casting reflections of misconduct in office upon a public officer or impugning his character, but without including a presentment or true bill of indictment charging that official with a specific offense against the state. And while those cases hold that the subjects of such extrajudicial reports are entitled to have those reports expunged from the official records, neither suggest that it is appropriate to quash a special purpose grand jury's report based on allegations similar to those that petitioner makes here. So you understand that? So basically, people who were being investigated by a special purpose grand jury, where there are allegations that were made, where these people ultimately are indicted or convicted, the court's like, yeah, that makes sense to quash what the special purpose grand jury does, because you're impugning someone's reputation who ultimately wasn't charged and convicted of a crime. But that's different than what's happening here, where this is being presented to a grand jury. The Supreme Court goes on to say, furthermore, this court has held that even where a defendant has established that a special purpose grand jury acted illegally, neither dismissal of the subsequent indictment nor suppression of the evidence was the proper remedy for the grand jury's overreach, because no violation of defendant's constitutional rights and no structural defect in the grand jury process occurred. Indeed, in the case called State versus Lample, we held that grand juries, unlike petit juries, are authorized to consider evidence without regard to its eventual admissibility at trial. And with regard to petitioner's request to disqualify Willis from representing any party in any and all proceedings involving him. We note only that petitioner has not presented in his original position either the facts or the law necessary to mandate Willis's disqualification by this court at this time on this record. For these additional reasons, petitioner has not shown that this case presents one of those extremely rare circumstances in which this court's original jurisdiction should be invoked, and therefore the petition is dismissed. So what's interesting too is, the process by which the grand jury hears information, the admissibility of the information that the grand jury is even given is not something that is considered. The admissibility ultimately at the time of a criminal trial, that can be considered so that a criminal defendant's constitutional rights are protected. But even if the grand jury relied on a defective special purpose grand jury report, that doesn't make it so that the grand jury's ultimate indictment is negated. You see? So that concept right there is now precedent that Fani Willis is going to cite in Donald Trump's petition that he's now brought and has got assigned to perhaps a more favorable jurisdiction in the 7th Judicial District. So Donald Trump's response to that, though, with his lawyers, just so you see what goes on here, Trump then filed an amended petition from his original petition filed on either July 11th, either July 13th or July 14th. Trump filed an amended petition just the other day because the Supreme Court ruled this way. Trump didn't say it, but this is why he filed an amended petition, and he included some new information. And the information he included is that Fulton County District Attorney Fani Willis was retweeting people who were saying to her, hey, retweet Fani Willis, get her more followers, and Fani Willis is holding people accountable, and that's why she deserves more followers. Give her a follow and support her campaign. So Trump says this shows her bias, that she's using this to get more followers and to raise money for her campaign. Here's what I want to say, because I want to be fair. I want to be critical of all parties when I think criticism is deserved. Same way I think Trump's motion is frivolous. I do think, though, with respect to Fani Willis retweeting things about getting her more followers and retweet, I don't think she should have done that. Do I think that is subject to disqualification? No, but she's certainly arming people like Trump with ammunition now to bring these filings. I mean, can you imagine if Special Counsel Jack Smith actually had a real Twitter account? I know there are parody accounts out there, but could you imagine if he had a Twitter account and was saying, retweeting things that say follow Jack Smith? No, that's unheard of. That's not what district attorneys should be doing. I don't think Fani Willis should have been retweeting or engaging with retweets here. And I think that it certainly, while should not lead to her disqualification, it gives an argument where it shouldn't have even been there in the first place. And that's exactly what Trump's lawyers do. You can't give them things like this to try to find a receptive judge to make that argument where you're otherwise going to prevail, right? So I think it's just important to just be real about that. So there you have it. I'm Ben Meiselas from the MeidasTouch Network. But ultimately, why I say Trump's screwing himself by filing in the Georgia Supreme Court is he's now created precedent against himself. And I read for you what that precedent is, which he would not have to contend with otherwise if I think he just filed this directly with the Superior Court where he should have filed it in the first place. Hit subscribe. We're on our way to 1.5 million subscribers. Check us out at patreon.com/MeidasTouch. Wherever you get audio podcasts, subscribe to the MeidasTouch podcast and have an excellent day.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.